Good morning, Your Honors. Attorney David, good morning, Justice Ireland. Attorney David Mirsky for Patricio Santiago, the defendant appellant in this case. I'd first like to address the issue of the motion for new trial that was denied by the trial court without any kind of a hearing. The basis of the motion was an affidavit of a material recanting witness with the name of Anthony Faria. Had different names in the transcripts, Faria or Farias, but I would call him Faria at this point. The issue here is whether serious consideration was given to this affidavit, whether the record was properly reviewed, whether the trial judge...
Well, it was the trial judge, so the trial judge was pretty well aware of the record in the case.
Yes, Your Honor. However, the judge didn't address key factors in the record. For instance, the closing, in the Commonwealth's closing, Mr. Faria's identification was cited as the first constant, according to the prosecutor. There was a lot of commotion in the scene.
I take it the judge really discounted the affidavit as not being credible.
He discounted it, Your Honor, but based on a standard that he applied, that even though he was using the language of the cases for reviewing a recanting witness's affidavit, he actually dismissed it because he thought that the witness held up well in cross-examination.
Well, he testified before the grand jury and at 2 trials, and this was several years later after the witness had been sentenced to 20 years in prison on another matter.
Yes, Your Honor. However, the trial judge, in reviewing the motives, potential motives for lying at trial, didn't credit the fact that at trial this witness had hanging over him a possible life sentence, which is a serious motive and a serious reason to favor at least the prosecution in one's testimony.
Mr. Mirsky, as a matter of fact, didn't the trial judge say, this court finds Faria's recantation affidavit to be utterly lacking in credibility?
Yes.
And then he explained in some detail how it was that he reached that conclusion. Now, if a trial judge doesn't give credit to an affidavit, they're not required to have an evidentiary hearing, are they?
Your Honor, it's certainly the discretion of the trial judge. It's favored, however, as I've cited under Patterson, the review in this case isn't perfunctory, even though you defer to some extent to a trial judge. In this case, the trial judge didn't even acknowledge the materiality of this witness's testimony. He didn't acknowledge the importance of what was stated in the affidavit. If the jury or if a finder of fact had accepted what Mr. Faria said as true, this would not be a conviction. And in this instance, we didn't have serious consideration. Both sides have agreed that when there's a recanting witness, that the courts are supposed to give serious, grave consideration of that affidavit, and that really can't be done unless the judge acknowledges all the details of the case, the important things that were that weakened the Commonwealth's case. For one thing, it should be noted that there were 2 trials in this case, and the first one was deadlocked, and this witness testified in the first trial. So not necessarily believed by a jury, regardless of what the trial judge felt or what standard he was applying. What we need to look at, I believe the standards point to whether a jury would find this possibly credible. And in this case, we had the other identification. This was basically an identification case. And the other witness Alan Montero had testified that he had been subjected to the details that he described of his interrogation by police could be characterized fairly as coercive. He said 10 to 11 hours of interrogation. He said that he was repeatedly, insistently, over and over asked, to recount the details of what happened. He also admitted in his testimony that he went to the police with the intention of lying, and so you have actually, in a sense, possibly two recanting witnesses. That the first one was allowed to testify at trial, Alan Montero, and here Mr. Ferry is not even getting a hearing, and not only was he not heard in court.
So what's going to happen at the hearing? He's going to repeat what he said in his affidavit, essentially? Well,
it's not simply that, Your Honor. This trial judge imputed motives to the witness that aren't on the record, and didn't address the fact that was on the record, that he was facing a life sentence, that he didn't have.
I take it when Mr. Ferry testified before the grand jury. He did testify before the grand jury, did he not? Or am I wrong about that?
I believe so, Your Honor, but
He was not facing a life sentence then. It was only when he was committed a crime between the grand jury and the first trial. Is that when he began to face that kind of consequence?
All I'm prepared to say, Your Honor, is he was facing it at the trial, and it's on the record of the second trial.
All right.
Now, he was the one, I gather, who on the night of the event went through some photos and identified Mr. Santiago as the person who had the knife, correct?
Yes, Your Honor, but he also had told police, and that this is in the second trial testimony, that the person he saw holding a knife had a red shirt, a bandana, and a hat, and there was testimony from a witness, Jessica Aguilar, at the trial, that the defendant was seen in the bar, which is the Dream Cafe, with a plain white T-shirt. So
Well, Faria, I thought that he admitted that he was lying to the police when he said he was wearing, when the defendant was wearing the red shirt. Isn't that what he said to police in his statement?
That's not how I recall it, Your Honor, but that may be true. Okay. I don't know that.
But wasn't there also testimony that the defendant raised an alibi defense? He said he was only in the bar for 10 minutes, and the alibi defense turned out to be a bust, and the police found the victim's blood inside the defendant's car.
Well, Your Honor,
I mean, there was other evidence that the defendant committed
There
this
was other
crime.
evidence, however, as far as the blood, first of all, that's true. That could be explained by not wanting to be caught up in this by being profiled as being a Hispanic, as there was an issue of a lot of Hispanic men being in the bar and some altercation with these patrons and with the victims.
I'm sorry. How does that explain anything? The fact that the victim's
well, maybe
blood?
he didn't want to be associated with being there at all, and that would be a reason aside from.
Yeah, but that doesn't put the
What would
blood
get
in the
the
car.
blood in the
No,
car?
the blood is a different matter, and the evidence there is that there was blood all over the area on the ground, and that any number of this mob of people that were coming out of the Dream Cafe, they all could have had blood on their shoes, and that there wasn't expert testimony about the stain, about able to pinpoint that to being actually reflective of a murder weapon. And in the prosecutor's closing, she said maybe it was the knife.
I thought that if the defendant's story was that he had come into the bar for 10 minutes, had left before this thing occurred. Was that not his story? Yeah. So again, how would blood get in his car if he'd left before it occurred? I mean, these are problems at the trial, and you can see the trial judge, having heard all of this, might be skeptical of Mr. Faria's recantation when he was in prison, the same prison system as the people he helped convict.
He might be skeptical, Your Honor, but he didn't. The fact is, he basically imputed motives that weren't on the record and according to the Commonwealth's brief, based on the fact that the trial judge had been the sheriff, I mean, I don't think that's considered grave for serious consideration of this witness's affidavit.
What-
Are you suggesting?
I'm sorry.
But I just wanted to, I mean, it seems to me that if one accepts your view, I'm not clear how an appellate court could ever accept a trial judge's view that an affidavit was not credible. Because it seems to me the implication of what you're saying is that the judge, in a way, was required to accept the veracity of that affidavit, at least to the point of having to test it with a hearing.
Actually, Your Honor, the way I perceive it, if you apply the standard that was applied by the trial judge in this case, you would never, almost have no chance of accepting a recantation, even to have a hearing on it, because the witness passed, through cross-examination, and his testimony wasn't shaken, and that was a reason the trial judge gave.
There was more. He also said that the testimony was consistent with his recorded statement to the police, was corroborated by Montero's trial testimony and the physical evidence that traces of White's blood were found in Santiago's car. Moreover, Faria's assertion that he identified Santiago due to pressure from police to provide a name is contradicted by an objective viewing of the videotaped interview, which reveals no coercion or intimidation by police, and enthusiasm by Faria to assist in the investigation.
Well,
The judge went on to say, finally, Faria's statement that he recanted to clear his conscience lacks credibility in light of the suspect timing of the affidavit. So he gave more than just that there was a recantation.
Well, Your Honor, there was evidence, in terms of the videotape, there was evidence as to Mr. Montero, Alan Montero, that he was questioned for there was a dispute over whether the 10 to 11 hours is actual or his perceived length of questioning, but that the story was gone over and over, and then it's put on, at the end of that period, put on videotape. That's one reason to view a videotape with skepticism. Another reason is that if he had a motive to favor the prosecution, there's no reason why he wouldn't be completely affable in coming up with somebody for when they're in an investigation, and he's got this he at least has an idea that he needs to help the police for himself. And that I would say that the trial judge did look at evidence, and as you're saying, and I acknowledge that, but he didn't look the things that he did that he didn't look at that particular thing, that the life sentence was hanging over this defendant, and also he gave more weight to the prosecution's case than was justified, especially since this other identification witness had admitted lying and had told the story of really being browbeaten by police, being isolated, being questioned, asked the same things over and over, 100 times or hundreds of times. And
This is Montero you're talking about.
Alan Montero, and he
is not recanted.
Right, that's right, Your Honor. I'd like to go on to the second issue, if Your Honors don't have any further questions.
Sure.
I would just want to point out that the prosecutor got before the jury through questioning the insinuation that the defendant or somebody had intimidated the witness, Peter Ruby, who was at the scene and did not identify the defendant in court and was not giving the answers that appeared to be asked for by the prosecutor.
Did the prosecutor, I mean, because the question was objected to and the objection was sustained, did the prosecutor make any reference to fear on the part of Mr. Ruby in her closing?
No, Your Honor.
So the only indication of this is that one objected to and sustained objection question.
No, it's not. I mean, Your Honor, this is I have quoted in the brief the whole questioning series, which
Right.
all shows, I believe it shows that the prosecutor has an idea of the evidence and is trying to communicate that through answers, through questions that are all being answered no.
Well, I
And
mean-
they don't have this evidence. That's the thing. They don't have the evidence. The prosecutor didn't come up to the judge beforehand, didn't offer a foundation for asking this, for saying, is there a reason you're afraid to say that? I mean, in the middle of this scene where there's a bar, a kind of a wild scene going on, and the prosecutor in her closing admits that witnesses have different stories because of the commotion, this possibility that the defendant is intimidating a witness is, without really any foundation for it, is strong evidence, and that's actually the kind of that is consciousness of guilt evidence that's not ambiguous, as I was pointing out. The other evidence I would say is ambiguous as far as whether he wanted to be placed on the scene or not.
But why?
this is-
But Montero, who testified, I guess, before this witness, himself said, I initially did not speak about who did it because I was scared. I didn't want to get involved. I didn't want to put my kid's life in danger. It seems that Montero's testimony puts in the fact that there is fear out there with regard to testifying in this case.
Well, Your Honor, there's no evidence that Peter Ruby was intimidated. There was no proffer made of it. And in the Commonwealth's brief, and when they're arguing about this, they're talking about his demeanor at trial. And that's why I pointed out the statement made by Faria on that tape, that he made a comment about Peter Ruby, the fact that he was a guy that didn't participate in things, was quiet and wouldn't speak and wouldn't do things with them, wouldn't play video games. And that demeanor is being used by the Commonwealth, even in their brief, to say that that he was being intimidated. And we just don't have that evidence, Your Honor. We don't have it. And that shouldn't be communicated to the jury. The prosecutor had to have that. And they don't have it now, and they didn't have it then. It's not in the evidence. And that's why
So you're suggesting there was no basis at all to ask the question. We know the question was asked, objection sustained, the judge instructed the jury several times that questions are not evidence, only answers are. But you're saying because there was no basis, absolutely no basis to ask the question, that the question was so improper, the jury
first of all,
verdict ought to be reversed?
I would say it was so improper because it was evidence being given by the prosecutor. However, as far as the instructions were not tailored to this misconduct. And I've cited Commonwealth versus Williams, which says that when you have misconduct like this, where the prosecutor's giving the evidence and it's not coming from, this evidence is that you, Peter Ruby, were intimidated not to speak, and that's why you're not saying.
What did Mr. Ruby tell, what did Peter Ruby tell the police? In other words, what was in the report that the prosecutor was trying to refresh the recollection with? Was it
I'm
something-
assuming that she's trying to have him say implicate the defendant. I'm
Well,
assuming.
I mean, do you know what it was that Ruby said to the police when he was interviewed? Because she's trying to use a report to refresh his recollection, and he says it doesn't do it. But I didn't know what was in that report.
I don't have that on the top of my head, Your Honor. But I would assume, I'm not saying that it was out of whole cloth, invented. As Your Honor said, Alan Montero raised that. But I'm talking about a very specific thing here. This witness was at the scene, at trial, is not identifying the defendant in court as a perpetrator. That's exculpatory evidence. And the prosecutor's telling the jury that I know this guy saw that defendant, and he's not telling you that. That's what's coming through her questioning.
Well, assume for the minute, hypothetically, that the police report did reflect some identification of the defendant by this witness, Peter Ruby. Would you think that's improper for the prosecutor to be asking these questions?
I think it's improper because what she's saying, you know, again, we have the videotape, we have reasons for reticence possibly by any witness to want to testify in a murder case, to say that there's intimidation, that you're afraid. You're afraid. Is there a reason you're afraid to say that? I mean, that has a lot of implications, especially when identification's an issue and credibility is an issue, and these witnesses have questionable credibility, all of them. And we also have the prosecutor acknowledging in closing that all the witnesses have different stories because this happened so fast. And so this type of thing, saying, is there a reason you're afraid to say that? And this didn't come at the...
Mr. Mirsky,
Yes?
your time is up.
Oh, I'm sorry, Your Honor. Thank you, Your Honors.
May it please the Court, Rachel Eisenhower for the Commonwealth. Both sides do agree on the first issue that a judge's duty is to give grave consideration to the credibility of a recanting witness's affidavit. In fact, they are not the only people in agreement. The judge himself notes this duty in the motion for new trial ruling. In order for a new trial to be granted, the evidence has to be both material and credible. Where it is clearly not credible, the issue of materiality doesn't even need to be reached. I would note, since it was asked, I do not know if Faria testified before the grand jury, but the indictment for Santiago was in 2003, and the incident date of the Faria criminal conduct was October 3rd, 2005. So it was almost 2 years later that the conduct occurred after the grand jury testimony, if he did testify.
So it's just a little bit before the first trial.
Just several weeks before the first trial that it occurred. As for the judge's reasons for finding it lacking in credibility, the judge is permitted to draw inferences from the evidence before him. The evidence before him included the docket of Faria's pending criminal charge. He could draw inferences from that. The defendant pled guilty in October 2006, and by December 2006 filed a motion to revise and revoke, suggesting that he was already unhappy with his sentence. As for issue 2, Peter Ruby's testimony didn't actually go to the identity of the stabber. He testified that he got outside the bar when Alan Montario and Anthony Faria were already helping Michael White. So by that point, the stabbing had already occurred.
But was the prosecutor trying to elicit testimony that Ruby saw a knife in the defendant's hands?
I think she may have been. I have not read the police report either that she was referring to.
Do you know if it's part of our record, that police report?
I don't know. I can provide it to the court if that would be of interest.
It wasn't marked for identification or marked as an exhibit of any sort?
I don't believe so.
And you don't know what she was trying to elicit from him as a government witness, Commonwealth witness?
I think she was trying to get him to reiterate whatever was in the police report, but I don't know what was in it. I think that the judge accurately said that on the foundation she had laid, the question was misplaced. She had not laid the foundation for that, and it would have been better practice to approach sidebar and explain the problem that she was having and her basis for believing it was community fear. She did believe that there was a community fear problem, even if she misunderstood his normally quiet demeanor as being specific to the case. That would still have given her a reasonable basis for perhaps thinking he was in fear, even if that is his normal demeanor. It may have simply been her misunderstanding. But
there was a pretrial motion to remove cell phones from everybody who entered the courtroom. Do we know what the basis for that motion was?
I do not know. I would imagine again that it had to do with community fear, but I can find that out.
Do you know if that's something? Does your office do that as a matter of course? Do you know?
I don't believe we normally do that as a matter of course unless there's some kind of gang activity. But but I don't actually, the trial happened before I joined the office, so I don't know what the thinking behind that was.
Now, at trial, was there any indication as to what the motive was with respect to this stabbing? I couldn't really discern a motive, and nor could I be sure. Am I correct that one witness said that the person who had the altercation with the victim was the stabber, and the other person said it was two separate people?
The initial incident seemed to be a fight about the pool table. The judge didn't let the conversation in, but in essence, the victim had been playing very successfully at a pool table. He was winning, and then at some point, he didn't want to play anymore and grabbed his quarters off the table and walked away. And at that point, the people he had been playing with became angry. Someone hit him, then the altercation arose. So my inference is that it had something to do with the pool table and some sort of perceived disrespect as a result of the fact that he was walking away after winning, and that there was some perceived slight to ego. But that's my inference. It was not expressly in the record what caused this altercation.
And was there any discussion of anything being said during the altercation or outside that would suggest either gang or some Hispanic Portuguese dispute? There was some sense that there was something about that going on too.
It's entirely possible, and what would also support that inference is that Alan Montero, the main witness, says that his initial thought was revenge, and he was going to go drive to a certain place and find out where these guys were. And so if to me, revenge suggests some sort of acknowledged group dynamic, but maybe he just meant revenge on this particular individual, the defendant. The defendant was not actually part of the pool table disrespect, if that's what you can call it. The bartender has him sitting at the bar, and then after the altercation at the pool table, the defendant rushes out of the door to join the fray. And then another individual, I believe it's Peter Ferreira, says that once the door closes, the defendant's no longer in the bar. And from that, you can infer that he went outside. And then the victim's friends Alan Montero and Anthony Faria, prior to his recantation, placed Patricio Santiago outside in the brawl. Alan Montero has him stabbing the defendant. If there are no further questions, then the Commonwealth would rest on its brief.
Thank you, Counsel.